Today I'll be talking about examination of witness. So in examination of witness, a witness will be asked question related to a fact in issue and they are required to answer to the relevant question presented to them. The examination of witness and provisions related to the same are dealt under Chapter 10 of Bharatiya Sakshya Adhiniyam. So the first provision with regard to examination of evidence is that order of production of witness dealt under section 140 of the Act. So basically this provision says that the order in which the witness is produced, who is the first witness to be produced, is related to the procedure that is given under the civil code or the criminal procedure code. However, in case there is no provision for the same, if there is an absence of law, it is the discretion of the court. Next provision with regard to examination of witness is the judge is to decide the admissibility of evidence, which is dealt under section 141 of the Act. So this provision firstly emphasizes that if either party comes to the court for giving evidence of any fact, the judge may ask the party whether the fact that is being, the alleged fact or the fact that is being produced is relevant to the case. So if it is relevant, then the judge will admit it based on relevancy. Secondly, if the fact that is proposed to be proved is one of which evidence is admissible only upon proof of some other fact, the other fact needs to be proved first. Thirdly, when there is a relevancy of one alleged fact depends on the another alleged fact, then it is the discretion of the judge to whether allow the first fact before the second fact or the second fact before the first fact. Next provision is with regard to examination of witness, the various kinds of ways the witness is examined. It is dealt under section 142. The first one is examination in chief. It is the examination of a witness by the party who calls him. The second one is the cross examination. This is done by the adverse party. The examination is done by the adverse party. The third one is re-examination, wherein the examination of witness subsequent to the cross examination by the party who called him. This is called re-examination. The next provision is related to order of examination. It is dealt under section 143. The first kind of examination is the examination in chief, then it moves on to cross examination, and then it moves on to re-examination. The examination in chief and cross examination should be related to the relevant facts. However, the cross examination need not be confined to the facts with regard to which the witness testified in the examination in chief. Next provision is related to cross-examination of person called to produce a document. It is dealt under section 144. Here, just because a person is producing a document, it doesn't make him a witness. He cannot be called for cross-examination unless he is called as a witness. Provision is relating to witness to character. It is dealt under section 145. So when you talk about witness to character, it means a person is giving evidence in a legal action with regard to the reputation, conduct and moral or the nature of the party. So here in the Act it says that the witness to character can be cross-examined and re-examined. The next provision we are dealing with is leading question. It is dealt under section 146. The meaning of leading question is any question that is suggesting the answer to that the person who is questioning is expecting is to receive is a leading question. For example, asking a person, "This blue hoodie is yours, right?" is a leading question. Now, leading questions are not supposed to be asked in examination in chief and re-examination in case it is objected by the adverse parties, except in case there is a permission of court, then they can ask leading question. Some other kinds of exception where leading questions are allowed are wherein the matters are introductory in nature, the matter is undisputed, or the matter is already sufficiently proved, or it is in the stage of cross examination. The next provision is regarding evidence regarding matters in writing. It is dealt under section 147. This applies to cases where evidence is given with regards to contracts, grant or disposition of property, and so on. So here a person is making a statement with regard to something that is a part of the document, or that is the content of the document, and the court is in the belief that the document should be produced. Then the adverse party can object evidence until the document is produced, or in another case until the facts have been proved, which entitles the party who called the witness to give secondary evidence of the same. The next provision we are dealing with is cross-examination as to previous statements in writing. It is dealt under section 148 of the Act. A witness who has given a previous statement which is in writing or which is reduced to writing can be asked questions with regard to the same. So, these questions can be asked without giving or showing such writing. However, if the intention of cross-examination is to contradict him with regard to the writing, then his attention must, before the writing can be proved, be called with regard to those parts that they want to use to contradict him. The next provision we are dealing with is questions lawful in cross-examination. It is dealt under section 149. In cross-examination, the questions can be asked to test his veracity, to discover who the person is and what his position in life is, and to shake his credit, even though it can be by injuring his character. Next provision we are dealing with is where the court decides when a question should be asked and when witness is compelled to answer. This is dealt under section 151 of the Act. Any question that is not relevant to the suit but it is going to injure the credit of the witness, it is up to the discretion of the court whether the witness is compelled to answer to the same, and the court even might warn the witness that he is not obliged to answer if they think that is right. While the court is examining the witness and exercising its discretion, the court shall take regard to the following consideration. The first one being that the questions are considered to be proper if the truth of the accusation conveyed by them would seriously affect the opinion of the court with regard to the credibility of the witness, with regard to the truthfulness of the witness on what matter he is testifying. Again, such questions will become improper if the accusation that they are making is very remote. It is not related to the character or the truth of the accusation. It won't affect any, even to the slightest degree. Then this question becomes improper. The question again becomes improper if there is a great disproportion between the importance of the accusation made against the witness character and the importance of his evidence. The court may, in certain circumstances it deems fit, it can come to the conclusion that the refusal from the witness infers or gathers that if the witness answers, it would be unfavorable. The next provision that we are dealing with is the questions not to be asked without reasonable grounds. So any question that is being asked in the previous section, it should be asked only where there is reasonable grounds for the accusation that is being made. The next provision we are dealing with is the procedure of court in case of being asked without reasonable grounds. It is dealt under section 153. If the court is of the opinion that there is a question that is asked is without reasonable ground, and if that question was asked by the advocate, they can report this to the High Court or any other authority to which such advocate is subject to in exercise of his profession. The next provision is with regard to indecent and scandalous questions, which is dealt under section 154. The court may forbid any kind of questions or any inquiries that is which is indecent or scandalous in nature, even if such questions have some bearing in the court of law. However, the same can be asked only if they relate to a fact and issue or to matters necessary to be known, where they have to, this should be determined to know whether the facts and issue existed. The next provision is with regard to questions intended to annoy or insult. It is dealt under section 155. The court forbids any question which is going to insult or annoy the person appearing, and even if the question is proper, but if the court feels that it is offensive in the form, these kinds of questions are forbidden. The next provision is with regard to exclusion of evidence to contradict answers to question testing veracity. It is dealt under section 156 of the Act, wherein in this Act, in this provision, a witness has been asked and has answered any question, and in such case there shall be no evidence that shall be given to contradict him. However, if he answers falsely, he may afterwards be charged with false evidence. There are two exceptions for the same. First exception being that if a witness is asked whether he has been previously convicted of a crime and he denies it, then the evidence may be given for his previous conviction. The second one is if a witness is asked any question which is going to impeach his impartiality, and he answers it by denying the fact, and he has contradicted. In such cases, evidence may be given. The next provision is question by party to his own witness. It is dealt under section 157 of the Act. The court may, in its own discretion, it may permit the person who is calling the witness itself to put any question which might actually be put in front of the witness only during cross examination by the adverse party, and the same witness can be used as evidence. The person is permitted to do so. The next provision deals with impeaching credit of witness, which is dealt under section 158. So the credit of a witness can be impeached in the following circumstances. The first one being by giving evidence of people who testify that this person is unworthy of credit, you cannot believe him. The second one is that he's been bribed or he's accepted an offer of bribe, or he has done any other corrupt practices. The third one being where there is a proof of former statement which is inconsistent with any part of his evidence, and hence it becomes contradictory in nature. The next provision is with regards to question tending to corroborate evidence of relevant fact admissible under section 159. So, in case a witness gives evidence of any relevant fact to corroborate evidence, then he may be questioned as regard to other circumstances which he observed during the time which the relevant fact occurred. So, if the court is of the opinion that such circumstances, if proved, would corroborate the testimony of the witness with regard to the relevant fact which he testifies, then the corroborative evidence is admissible. Next provision is regarding testimony as to the same fact which is dealt under section 160. Any former statement that was made by witness with regard to the same fact about the time when the fact took place, or before any other legally competent authority to investigate the fact, the same may be proved to corroborate the later testimony of the same fact. The next provision is with regard to what matters may be proved in connection with proved statement relevant under section 26 or 27. Section 26 deals with cases in which statement of relevant fact by a person who is dead or cannot be found is relevant. Section 27 deals with the relevancy of certain evidence for proving in subsequent proceedings the truth of the fact that is being stated. So, whenever a statement which is relevant under 26 or 27 is proved, all matters may be proved either in order to contradict the same or to corroborate it, or to impeach or confirm the credit of the person by whom it was made, which might have been proved if that person had been called as a witness and had denied upon the cross examination the truth of the matter that has been suggested. The next provision is regarding refreshing memory. Witness while under examination can refresh his memory by referring to any writing either that is made by him at the time of the transaction or after soon afterwards, wherein they feel that the transaction was at that time very fresh in the memory. However, if they refer to any such writing by any other person, after he is read, they should know whether the fact is correct or not. The second provision is that when he is refreshing memory by referring to certain document, with the permission of court, he can use or refer to a copy of such document. However, if the court should be satisfied that there is sufficient reason for the non-production of the original document. The next provision is with regard to testimony to facts stated in document mentioned in section 162. Witness may testify to facts that is mentioned in any documents with the same way he as in the previous provision, where he has no specific recollection of the facts, but he is sure that the facts were correctly documented or recorded. For instance, let's say a bookkeeper has to testify with regard to some records that is maintained by him in the books. However, he doesn't have the recollection of the same, but he knows that the records in the books are maintained properly, so the same can be given as evidence. The next provision is the right of adverse party as to the writing used to refresh memory under section 164. So, any writing that has been referred under the previous provisions shall be produced and shown to the adverse party if they require it, and the party may also cross-examine the witness with regard to the same. The next provision we are dealing with is production of documents under section 165. The court may ask the witness to give the document which is in his possession or power without any kind of objections with regard to production or its admissibility. If the court thinks it requires, it may inspect the document, and for the same purpose, if the court thinks the documents needs to be translated, they can direct for the translation, and also direct the translator to keep the contents of the document secret unless the document is given in evidence. And if the interpreter disobeys such direction, he will be punished according to the provision of Bharatiya Nyaya Sanhita. Giving as evidence of documents called for and produced on notice, it is dealt under section 166. When a party calls for a document and the notice to produce the same is given, and such document is produced and inspected by the party calling for its production, in case the party requires the same document to be produced as evidence, he is bound to do the same. The next provision is using as evidence of document production of which was refused on notice, which is dealt under section 167, where a party is called for document again with a notice to produce is given, but the party refused to produce the document which he had the notice to produce, then he cannot use the same document as evidence without the consent of the other party or the order of the court. The last provision that deals with the examination of witness is the judge's power to put questions or order production, which is dealt under section 168. A judge may, for the purpose of discovery or obtaining proof, ask necessary questions. These necessary questions can be in any form, can be made at any time, can be asked to any witness or of the parties, and with regard to any facts. And importantly, there is no objection that can be made by any parties or their representatives. In addition, there can be no cross examination of any answer given under this section without the leave of the court.